Hello ladies and gentlemen, my name is Kalisa Dipura.
I'm Lorraine Manyaran.
My name is Anna Mbewe.
And I'm Shamli Simzos.
I'm Tavisen Mawiri. And behind the camera we have Takuzo Marozwa, Tinotina Chinamasa and Wayne Nyamfila. So we are part 2 students from the University of Zimbabwe, and we are dealing with our assignment question on breach of contract. And we are going to be focusing more on the remedies that are available for a breach of contract. So before we get into understanding of what a breach of contract is, we need to first understand what a contract is to begin with. So a contract is an agreement between two parties that is enforceable at law. This is what a contract is. So a breach occurs when parties to a contract violate the obligations and the rights and the duties that they have within this contract. So to help us get into depth to what a breach of contract is, so that we can be able to understand the remedies that are available, we are going to be helped by my co-colleague Tarisai Mawira, who is going to take us into breach of contract, what it really is, and give a rundown of the remedies that are available for a breach of contract.
Okay, so now in explaining what is a breach, Dr. Maja actually said a breach occurs when a party to a contract fails to honor or to stick to his or her obligations and the duties that were created by a contract that was made. In other words, it just means a violation of any of the agreed upon terms and conditions of a contract. Then the breach of contract, there are categories of breach of contract, and they are actually categorized into 3 forms, as was stated by Dr. Maja. The first category is the category of breach according to when performance was due, also breach according to which party failed to honor his or her obligation, and also breach according to the impact on the essential elements of a contract. So now, breach of contract according to when performance was due, it is further classified into 2. We have got what we call anticipatory breach as well as more performance. Now on anticipatory breach, there are 2 examples of such, which is prevention of performance as well as repudiation. On the other hand, malperformance, it comprises of mora ex re and mora ex persona. Now, on breach according to which party has failed to perform now on breach according to which party failed to honor their contractual obligations, it consists of mora debitoris and mora creditoris. On the 3rd category, which is breach according to the impact on the essential elements, it is further divided into 2, which is breach going to the root of the essential elements, and breach that does not go to the root of the essential elements. Now, the 3rd category of breach of contract is breach according to the impact on the essential elements of the contract. This is further divided into 2, which is breach that goes to the root of a contract and breach that does not go to the root of a contract. Now, when is this the end? When a contract is breached, is it even the end? R.H. Christie stated that the significance of a breach in the eyes of law is that the other part is now entitled to a remedy. So a breach of contract is not the end of it. When a contract is breached, we can move on to the remedy so that the other party cannot face unjust enrichment or unjust losses. Actually 4 remedies of a contract that we are going to discuss, beginning with specific performance, going to an interdict, also going for or claiming of damages, If all these three fail, a party can go as far as cancelling a contract. As you can see, as we are proceeding with our presentation, as my colleagues are going to explain with that, you are going to understand how these remedies are claimed and how can they be enforced at law.
Okay, thank you so much, Teresa. So we have just gone through what a breach of contract is, and we have understood that for a breach of contract there are remedies that are available, and breaching a contract is not the end to the contract, but there are remedies that can be employed. So we are now going to get into this remedies. As we had earlier on alluded to, that the focal point of this presentation is to look at the remedies that are available for a breach of contract. So we are going to look at the remedies. So the first remedy that we are going to look at is specific performance. And Anna is going to take us through specific performance, what it entails, and all the requirements that are there for a person to actually be able to claim specific performance as a remedy.
Okay, so thank you, Calista. I'll be looking at specific performance as a remedy to a breach of contract. Okay, so according to Dr. Maja, specific performance is the primary remedy for a breach of contract. Okay, so specific performance, it aims to uphold the contract and obtain the performance as promised, right? So by claiming specific performance, the innocent party is asking the court to order the defaulting party to exactly do what he or she was supposed to do, put differently, to fulfill his or her contract obligations. Okay, so moving on, I will start with introducing a case. For example, in the case of Intercontinental Private Limited versus Nestle Zimbabwe, Nestle was supposed to deliver a certain quantity of milk to Intercontinental, but then it failed to do so in time. So then Intercontinental then went to the court for an application for specific performance. The general rule under the Roman Dutch law is that an innocent party has the right in every case of breach of contract to a remedy of specific performance, as shown in the case by what the Intercontinental Private Limited did, right? Okay, so an innocent party can claim for specific performance unless there are exceptional circumstances which justifies refusal or an order for specific performance. Okay. So moving on, according to Farmers Cooperative Society versus Berry, another case again, every party to a binding agreement who is ready to carry out his own obligation under it has a right to demand from the other party so far as it is possible. Right. So in general, we are just talking about specific performance. Usually specific performance happens when the other party fails to do what they were supposed to do in time, but still what they have failed to do can still be done, even if it's still after time, right? Okay. So the right to claim specific performance of a contract is premised on the principle that the appellant must first show that he has performed all his obligations under the control, or that he is ready, able and willing to perform his own side of the bargain. It therefore follows that the court will not decree specific performance where the petitioner has broken the contract or made a material default in the performance. Also, it is very important to note that the court has discretion whether or not to grant specific performance. Okay. In the case of Mfakosa Housing Cooperative Society versus Zimbabwe, it was established that the court's discretion includes compelling the performance of a personal obligation under a contract. In Minister of Public Construction and National Housing versus Zescon, the court held that the court's discretion should not be exercised arbitrarily or capriciously. Okay. The case of Farmers Cooperative Society versus Green, the court held that a party in breach of contract does not have the option of paying his default by paying damages, but the injured party may elect to demand specific performance, subject to the discretion of the court. Okay.
This stresses out that the court had to grant specific performance or deny it to meet the ends of justice. For example, in the Makozori case, the court could not exercise the discretion to compel specific performance of a personal obligation under a contract because doing so would infringe on freedom of association by compelling a citizen to associate with another against his will, even if he is bound in a contract. Moreover, specific performance will not be granted when compliance would be impossible, as when the party has contracted to deliver the property of another, or where undue hardship would be imposed on the party in default. This is articulated in Haynes v. King Williamstown Municipality. Specific performance cannot be granted in a contract for personal services, as shown in Winterton Homes and Hills v. Patterson. The Supreme Court in Joma v. Amalgamated Motor Corporation, where there has been a bitter relationship between the employer and the employee. Other circumstances where specific performance is not granted are where damages would adequately compensate the plaintiff, where it would be difficult for the court to enforce its decree, where the thing claimed can be readily bought elsewhere, where it would operate unreasonably hardly on the defendant. So, generally, specific performance is the primary remedy for a breach of contract. But it has some exceptions, and the court cannot force a party to take specific performance where there is a bitter relationship between the two parties. Specific performance can only take place when the appellant wants that, and the innocent party is the one that really wants the specific performance. This is all under specific performance. Over to you, Calista.
Thank you so much. That was Anna on specific performance, the primary remedy for a breach of contract. Now let's hear another remedy that we have for a breach of contract, which is damages, which we're going to be led through by Lorraine, who is going to explain all about damages, the requirements that are there for a person to be able to claim damages.
Thank you, Calista, for giving me this time to discuss more on damages as another remedy for a breach of contract. So damages are claimed only for financial losses. And the Lopez Classic is in the case of Victoria Falls and Power Company Limited versus Consolidated Langat Mines Limited, where the court held that sufferer by such breach should be placed in the position he would have occupied contract been performed. So far as that can be done by the payment of money and without undue hardship to the defaulting party. And this is explained in the case of Roland Electro Engineering Private Limited versus Zimbabwe. According to Mdukuti versus FCM Motors Private Limited, the general rule of damages for breach of contract are also assessed at the time of the breach of contract, the time of performance, or the time of cancellation, meaning that damages can be claimed at any time. There are also requirements for a claim of damages, and these include the party claiming damages must prove that there is a breach of contract by the other party. The innocent party must prove the defaulting party breaching the contract. There should be evidence that there was a breach. And the second requirement is that the breach should have caused patrimonial loss. Breach of contract must cause financial losses present and future. For example, in the case of Administrator Natal versus Edward, the court held that a party to a contract cannot claim for non-patrimonial loss, such as pain and suffering, mental anguish, sentimental loss, physical inconveniences, and many more in the law of contract. Patrimonial losses can be loss in relation to performance, consequential loss, lost profits, or wasted expenses. The third requirement is that there must be a causal connection between the breach and the loss, factual causation. Here, the conditio sine qua non test, but for test in court. is used to ask whether the loss claimed would have occurred but for the breach of contract. The wrongdoer's conduct should have factual caused the harm suffered by the innocent party. The duty to pay contractual damages therefore arise from factual causation. The fourth requirement is the loss is not too remote. The alleged loss must be reasonably foreseeable at the time of contract. This means that for the innocent party to claim damages, one, it should have all the evidence that there is a foreseeable chance that there will be a breach of contract. So, for a party to pay damages on the innocent party, there should be evidence that there was breach of contract, and also patrimonial losses. We should see the losses, and also there should be a connection between the breach and the losses.
So damages was the remedy that Lauren took us through. So next we're going to look at interdict and the requirements that are there for a person to be able to claim interdict. And Tarisai is going to take us through the whole process and the whole remedy of interdict. So at this moment I'm going to hand over to her as she explains further to us on what interdict is, what requirements are there, and what sources do we have in our law that supports this requirement and to claiming interdict as a remedy to a breach of the contract.
Thank you, Kalisa. So now I'm taking you through what is an interdict, the remedy of interdict, how does it work in our law. So our very own Dr. Maja, he defines an interdict as a court order either restraining a person from doing a particular act or compelling a person to do a specific act. Generally, we have got three categories of interdicts. We have got prohibitory interdicts, we have got mandatory interdicts, and also we have got restitutionary interdicts. So now, a prohibitory interdict, this is an order restraining a person from doing a particular act. Let's take, for example, we have got the contract for restraint of trade. In such contracts, if a person or the innocent party saw that the other party who is bound by a contract of restraint of trade is about to do something, that person has to rush to the court and get an order so that he can stop the other party from doing that which he is about to do, which is contrary to their contract. Now, a mandatory interdict, it is an order compelling a person to do a positive act in order to remedy a wrong. Let's say in a contract, the other party failed to do or to perform which was actually agreed in a contract. The other party can have that order that can mandate the other party to have specific performance and desist from more performance that they have already done. Now we have got a restitutionary interdict. A restitutionary interdict is an order compelling a person who has disposed another person of his property to restore possession. This type of an interdict usually is used on spoliation orders, where the other party unlawfully dispossesses the property of the other party, and the innocent party now has to go to the court so that they can have an immediate order that is going to stop or that is going to help him to be given back his property that was taken unlawfully by the other party. So I think from what we have discussed so far, you can see that an interdict is a remedy, an immediate remedy that is given to parties to a contract. Usually, in a state of emergency, you just want things that are quick to stop the breach of contract, or else to ensure specific performance. Now, according to CJ Nigel, where a party to a contract realizes that the other party acts or intends to perform an act which he agreed to refrain from doing, or which he is in conflict with his contractual obligations, the appropriate remedy of the party who stands to be injured by the impending breach of contract is an interdict. Now I think Nigel here is just trying to tell us circumstances where we can, a party can claim for an interdict for it to be successful. As we are moving on, interdicts may be either interim or final, which means they can be just for temporary purposes, or they can be the final order or the final judgment of the court on a certain issue. For an interim interdict or for a temporary interdict to be granted, we are held by the case of Philips Electrical Private Limited versus Gwanzura. This is a Zimbabwean case. It was held that the innocent party has to establish a prima facie right, a well-granted apprehension of irreparable harm if the interim relief is not granted, and the ultimate relief is granted, that the balance of convenience favors the granting of an interim interdict, and that the applicant has no any other satisfactory remedy. So now we are giving, this case was laying out the requirements for one to be successful in claiming for an interdict, which means you must have a prima facie right, a well-grounded reason for claiming that, and also you have to satisfy the court that you don't have any other thing that you can do, which means a remedy of interdict is subject to other remedies. You have to seek other remedies first. If you fail, then you have to resort to interdict. Also, it is important to note that the possibility of the applicant to claim for damages cannot be a satisfactory remedy for purposes of granting the interdict. The point that is being raised here is the possibility that the applicant can claim for damages and can be satisfied cannot stop a person from claiming interdict. This position is articulated in the case of Hilbron versus Blinard. This is a foreign case which, in this case, it was held that an injury which could give rise to a claim in law is apprehended, then I think it is clear law that the person against whom the injury is about to be committed is not compelled to wait for the damage and sue afterward for compensation, but can move the court to prevent any damage being done to him. I think this case is showing us clearly circumstances where a person can jump for an interdict. We are given that where a person, you see danger coming, you cannot wait to be injured and then claim for compensation. CJ Nigel lays out typical situations in which the interdict can be used, which are: one, where it becomes clear that a party intends to act contrary to an agreement of restraint of trade. These are just circumstances. Then two, where it appears that a lessee intends to sublet the property in contravention of his contract with the lessor. And where a seller, before delivery of the object of sale to the purchaser, sells the same object to the other purchaser and intends to deliver that object to the second purchaser. So it explained what you have asked me to do, and I think everything is clear. And if there are further questions, you can just ask me. I can elaborate and explain more. Thank you.
Thank you so much, Sherry, for that detailed information on how interdict works. So now we're going to look at the last remedy that is there for a breach of contract, which is cancellation. And Shamis is going to take us through cancellation as well as the requirements that are needed for cancellation. So I now hand over to you, Shamis, to explain more on cancellation.
Thank you, Calista. Now I'm going to look at cancellation as a remedy for breach of contract. So this remedy is cancellation, or can be called rescission. So cancellation remedy aims at ending
contract. It places the parties back to the positions they were before they had entered into a contract. So the effects of rescission or cancellation is twofold. Firstly, cancellation extinguishes all existing and future unfulfilled obligations under the contract. Secondly, cancellation creates an obligation to restore any performance that was made. According to Maja, cancellation is a remedy which is extraordinary, which can only be claimed in specific circumstances. So now I'm going to take you through the requirements that are needed for one to claim cancellation. The first requirement is the right to cancel. The second requirement is the ability to restore performance received. The third requirement is the exercise of the right to cancel. So now I'm going to explain the first requirement, that is the right to cancel. The mere fact that a party has breached a contract does not justify cancellation of a contract. Cancellation is allowed where one party is immoral or has committed a breach which goes to the root of the contract. In the case of Zimbabwe Transmission and Contribution Company versus Tech Power Creative International, the court held that the breach of a material term of the contract, or the breach that goes to the root of the contract, or a fundamental breach, or a breach of essential terms of the contract justifies cancellation. In another South African case of Autorian Properties versus Maroon, the court held that rescission of a contract or cancellation of a contract is only permissible if a breach occurred of the term which goes to the root of the contract, and the materiality of the breach is, according to those authorities, also a relevant fact in the determination of rescission should be ordered or not. So now I'm going to move on to the second requirement for cancellation. The second requirement is the ability to restore performance received. As you understand that cancellation involves undoing consequences of a contract, as I have mentioned earlier, it creates an obligation to restore performance which had been received by any party in the contract. So the party seeking cancellation should be able to retain any performance that he or she had received in terms of the contract, together with any proceeds of that contract. The innocent party should restore any performance or any monetary equivalent of that performance which he or she had received from the other party. However, an innocent party that is unable to restore performance is allowed to cancel the contract if in his inability is not due to his fault or he is not enriched by the performance made. It is important to note that even the defaulting party in an obligation to restore performance, if he or she can restore to the innocent party, has a right to claim any loss incurred in the form of damages. Now I'm going to explain the third requirement for cancellation, which is the exercise of the right to cancel. The right to cancel is exercised by way of a notice of cancellation. A notice of cancellation must be expressed. It should expressly mention the intention of an innocent party to cancel the contract. It should be communicated to the party which is involved. The innocent party will lose the right to cancel the contract if he elects to uphold the contract or delay cancellation in any way that makes the other party believe that the innocent party has elected to uphold the contract. For a notice of cancellation to be effective, it must be clearly and unambiguously conveyed to the guilty party the innocent party's election to bring the contract to an end. It must embody an unqualified, immediate, and final decision to treat the agreement as to an end. A rundown on what I was explaining on cancellation as a remedy for breach of contract. Firstly, cancellation aims at ending the contract. It takes the parties back to the root of the contract where they were before they had entered into a contract. And the requirements for cancellation are the right to cancel, the ability to restore performance, and the exercise of the right to counsel. Thank you.
Thank you so much, Shaliso, for taking us through cancellation. So this is the end of our presentation. But before we close, I'm going to give you a rundown of the things that we talked about. So we talked about the basic definition of a contract, which is an agreement that is enforceable in law. And we see when a person or a party violates this agreement, they have committed what is known as a breach of contract. And there are many types of breach of contracts that are there. And there are remedies to this breach of contract, which was the focal point of our discussion, where we were looking at the remedies that are available for the breach of contract. The first remedy that we looked at was specific document, which is the primary remedy to a breach of contract. We also looked at interdict, we looked at damages, and finally we looked at the extreme end of the remedies that are available for a breach of contract, which is cancellation, which suggests ending the contract altogether. Thank you so much for watching. Happy viewing.